this type of contract as a commercial transaction. Okay, so that's number one. Number two, you didn't touch that one, or you forgot. Number two, he was of the view that at any rate, even if the Belgian state would have become suable and unable to plead immunity, this was a transaction that was done for her by our ambassador. And our ambassador enjoys immunity under our Diplomatic Privileges and Immunities Act. And this one, the way I take it up is, we usually tell the student to remind me of the rules relating to incapacity. When in law of contract, they taught us that an infant was incapable. And they also taught us that it was for his benefit. So if an adult engages an infant as his agent, should he be the one benefiting from the incapacity of the infant, as opposed to where the facts are reversed and it is the infant that engages an adult whose incapacity is relevant for determining immunity from suit? Is it that of the government of Belgium or that of the government of Belgium's employee, the ambassador? Do you understand? The principle in agency is qui facit per alium, facit per se. Am I correct? He acts by himself. He who acts through another. So who is acting for who between the ambassador and the Belgian state? Obviously, if only my Lord had looked at the issue more closely, he would have seen that the agent between the two of them is the ambassador, while the principal is the state. How can you hold the principal free in circumstances where if he had acted by himself, if he would not be free, but because he acted through an agent, you are saying he's free? That is illogical. That's like turning logic on his head. And so the reasoning of my Lord, with profound respect to him, may not really be correct. And a judge with a mind of helping the masses of the Nigerian citizens who will always be the victim of this immunity rule would not have reasoned that way. Okay? So move to Ll.M. Move to Ll.M.
Very well, sir. Thank you, sir. So the next one is the case of Ll.M. versus the government of United Kingdom and another. So in that case, the appellant was actually involved in an accident with a Land Rover Defender Jeep owned by the first respondent, which is the government of the United Kingdom, and a Nissan Urban Bus. So the appellant sued the respondent for damages due to the respondent's alleged negligence. The respondent challenged the trial court jurisdiction, arguing that the fourth respondent was a foreign state and the second respondent was a member of the diplomatic mission in Nigeria, entitling them to absolute immunity from suit and legal process. In this particular case, we noticed that the court expressed willingness to consider the commercial transaction exception, but actually rejected the argument that immunity should not apply when a foreign state is sued in Nigeria for damages caused by its agent to a claimant's property. So the court also dismissed the counsel's reference to the Supreme Court decision in Aguna versus Nigerian Tobacco. So the gist of the Aguna versus Nigerian Tobacco actually relates to the common law rule, which state that a common law rule is to be part of a Nigerian law if abolished by a post-1900 English case. In this case, we noticed that the court was actually fixated on the point that it will not apply any case that is decided after 1900. And as a result of that, it refused to consider the commercial transaction exception in this case, and then apply and then made the statement or the decision rather that the government of United Kingdom cannot be held liable or sued in Nigeria with respect to the accident. So that is the gist with respect to this case, sir.
Okay, my comment. You got it, but you didn't get the gist correctly. What his lordship said, what the presiding justice of the Court of Appeal said in that case was that he has no problem with the reasoning of Lord Denny in Trentex and CBN, but that Trentex and CBN was a contract matter, that he cannot find any authority that would apply that type of logic to a course of action that falls under tort. Okay? So for him, it doesn't fall within the commercial transaction situation because it was not a transaction, it was an accident, it was a tort. And so to rely on principles or ratios like that of Trented and CBN is to stand logic on his head. Okay? Then, but there was a point his lordship got correctly. His lordship also dabbled into the argument whether the issue is sovereign or diplomatic immunity. And he proceeded differently from Justice Akpata in Crema Italo. Unlike Justice Akpata, he thought that it was clearly a matter of state immunity. Okay? He agreed that it's not a question of diplomatic immunity when you sue a foreign state. Even if you are suing the foreign state for what was supposed to be the wrongdoing of its ambassador, the latter acts for the former. And so the former is the one whose immunity we are talking about. So he was willing to agree that it's a state immunity issue. He was also willing to agree that the secret immunity should apply. But he now distinguished the fact from what he said he knew about the secret immunity, which is that in cases like Trented and CBN, we are talking purely of a commercial transaction, and that this is a case of a tort, and so you cannot find correlation between the two. Okay. Now,
yes, sir.
Why was Agunani and Nigeria Tobacco Company cited to him? That's a case I love a lot. What happened in Agunani was that somebody was trying to raise a defense of common employment. Defense of common employment was, however, defense of common employment has always been part of the common law until it was abolished by statute in England. Now, when other parts of Nigeria enacted that statute to operate within their territory, North did not bother to do that. And so it was assumed that in the North, the defense of common employment was still applicable. As a matter of fact, this retired justice who wrote books on commercial law, Orojo, expressed such an opinion, and the opinion was relied upon by counsel, that is Agunani. But at the end of the day, the Supreme Court rejected that opinion and said that if a post-1900 statute in England abolishes any principle of the common law, that principle, ipso facto, I mean, by virtue of that abolition, ceases to be part of Nigerian law, and that those of the other, the legislatures of the other regions that were enacting statute, we are just wasting their time. They didn't need to enact any statute. Once it was abolished in England, it has ceased to be the law. And so, why was that decision thought to be useful? Okay? And was cited by council. The reason is that council also wanted the court. Council also wanted the court to do as an English court would have done in that circumstance. Council relied on, I think, section 5 or 3 or so of the State Immunity Act in England. That section provides that where the conduct of an employee of a sovereign state causes proprietary or personal injury to someone in the forum, okay, that sovereign state will not be able to plead immunity when it is sued vicariously for that act. So, in other words, we are the facts to have occurred in England with, say, Nigerian embassy being the one being sued in England. Okay? The Court of England will not allow Nigeria to plead immunity because by section 5 of their law, the wrong conduct of Nigeria's employee in England that has resulted in injury to someone in England will not be covered by immunity. So the council was trying to piece them together to say that, look, yes, if the position before was that the sovereign would have enjoyed immunity, okay, at common law, okay, that common law position has now been abolished by that section 5 of the State Immunity Act of 1978 in England. And Agunade and Nigeria Tobacco Company has now taught us that once a common law principle has been abolished by an English statute, it has ceased to exist. So, invariably, what he was trying to argue was that, yes, immunity in that type of circumstance would have been held out at common law. But given Section 5 of the State Immunity Act 1978 in England, that immunity has been abolished. So Nigeria, following Agunade and Nigeria Tobacco Company, a Supreme Court decision, should also deem that insofar as we rely on the common law for that position, the common law has been altered. And the new position is that in that type of circumstances, nobody will be able to plead immunity. Okay? Well, one will commend the council for its industry, but he was struggling too much. Do you know what he should have said? What he should have said in answer to the argument, restrictive immunity only relates to contracts, is to say, well, restrictive immunity or absolute immunity or whatever immunity is a doctrine of customary international law. And one of the major characteristics of anything that you call custom is flexibility. The position can change. The real ratio from Trented and CBN is not just that restrictive immunity applies, but that what the court of a country is to apply as customary international law is whatever customary international law is as at the time a case comes up. Okay? And how do you know what the position of customary international law is? It's very simple. Customary international law mirrors the uniform practice of the world. And so, how do you know the uniform practice of the world? Look at the existing state legislation on the matter. Look at the existing treaties on the matter. Okay? And look at existing municipal court decisions on the matter. If the court had done that, the court would have found that what it eventually did was to conserve Nigeria to the stagnancy of absolute immunity by not doing what the world is doing. So customary international law, according to Trentex and CPN, is part of every country's municipal law. It doesn't need incorporation. And customary international law cannot be affected by a system of precedent. So when customary international law is to be applied as governing as the governing law on a matter, then it is the current customary international law. And so that practice in England is not the only one doing it. It is the practice of the world today. And that has always been our recommendation, that in the absence of a state immunity legislation, Nigerian courts should brace up to the application of customary international law as their standard in determining whether a sovereign should enjoy immunity or not in particular circumstances. Okay?
Yes, sir.
So go to the next case. Can we go to the next case?
Very well, sir.
Next case?
Yes, we have two more cases. So the next case is the case of African Reinsurance Corporation versus Ll.M Consult Limited. In that case, the appellant and the respondent entered into an agreement wherein the respondent provided building construction consultancy services to the appellant. The agreement included a clause that stipulated that any dispute between the parties must be referred to arbitration. A dispute arose regarding the respondent's professional fees, and as per the agreement, it was referred to an arbitral tribunal. The tribunal actually ruled in favor of the respondent. Then the respondent filed an originating summons at the High Court to enforce the arbitral award. In response to the application for enforcement, the appellant sought to set aside the respondent's suit, arguing that it was immune from legal process and that the court lacked jurisdiction. The Court of Appeal upheld the High Court's decision to enforce the arbitral award against the appellant, noting that the issue of the appellant's immunity or waiver thereof had not been relevant in the case. And as a result of that, the case of Fatai was rendered irrelevant. So the Court of Appeal dismissed the appeal, holding that a government department engaging in a commercial transaction is not immune from legal action arising from that transaction. The court stated that restrictive immunity, when properly applied, has beneficial effects on business transactions between nations and their citizens, aligned with the modern trend of promoting international business. In the pronouncement of the court, restrictive immunity properly applied will have salutary effects on the business transaction between foreign or independent nations and their citizens, including legal fractions. They are in accord with modern trend of promoting business between independent nations. So despite being in contradiction to previous decision by the Court of Appeal and Supreme Court, this decision has been praised for its progressive stance. So that's all with respect to this case, sir.
What is your... Does this decision not suffer from the same criticism of the Fataye decision? I told you in the Fataye case that Nigerian courts do not appreciate that the principle, as far as immunity of international organization is concerned, is not the same when you are talking about immunity of international state institutions. State agency and instrumentality will earn their immunity through the state. But international organizations do not earn their immunity through any particular state. And so the whole idea of retrieving immunity and all of that does not apply to international organizations. Okay? I have an article that I published in the Journal of Africa and International Law, something like that. I think that journal is published in Kenya or somewhere, where I look at the immunity of international organizations from suit. The consideration is entirely different from what our courts are addressing. As a matter of fact, I'm sure that some of the judges, by the time they understand the issue before them, they will agree that they relied on counsel address and gave a judgment that has no relevance to the fact before them. There is a difference between immunity of state and immunity of international organization. African Reinsurance Corporation is an international organization. The principle regarding immunity of international organization, as demonstrated by the European courts, is if an international organization has our own internal mechanism for addressing complaints, whether by employees or by third parties, state courts would respect that. Okay? Would respect that. But if it doesn't have, the international organization will be as suable as anybody, because according to the European courts that have given plethora of decisions on this matter, the obligation not to deny citizens a hearing is higher in hierarchical order than the obligation to respect an international organization. And so you will see several cases where international organizations have been taken to court. So if you apply that principle, all of the decisions in the African Insurance Corporation cases, you will find have been wrongly given. Even if you would like, you see, the issue is this. If you take Ll.M Consultant and JDP Construction in the context of restrictive immunity, you clap for the two cases because they show that the judges are now tilting towards restrictive immunity. But the problem is that it's like applying a correct principle in a wrong circumstance. African Insurance Corporation is not a state and is not an agency or instrumentality of any state. Therefore, the question of absolute restrictive immunity does not apply to it. Okay? The issue there is third parties that sue international organization in state courts. When we state courts refuse to hear them on the supposed immunity of the international organization. And the answer that the European courts have given is that, well, if the international organization has our own internal mechanism, if it has our own internal mechanism an opportunity has been given to these third parties to seek redress, then you respect the international organization and allow our decision to be. But if it has no internal review mechanism, then it has to be subject to the jurisdiction of state courts. So go and read that my article. Go and read it and see why basically, even though we like the judgment in Ll.M Consultant and JDB Construction, in the context of restrictive immunity, we must acknowledge that it was an inopportune time to throw in restrictive immunity because it wasn't a state or an agency of a state that was claiming it. It was an international organization that was claiming it. And so the relevant principle ought to have been applied, which would have resulted much more easily in the same answer anyway. It would have resulted much more easily in the same answer. Okay? So I think on that note, I will discharge you people. Let Group 14 present their paper quickly.
Thank you, sir.
Group 14.
Good evening, sir.
Good evening. What's the title of your paper?
The title of our paper is Immunity of International Organization, Diplomatic and Consular Agents from Local Suits under Nigerian Law.
Good.
And I am Damilare Lekoya. With me, I have Oluwaseyi Ebenezer Osho and Victoria Hiroma. Are they in class? I believe they are in class.
I'm here. I'm in class.
Sir. So I'll be taking the introductory part of the paper before I hand over to my other colleagues. So the concept of immunity for diplomats and consular agents and international organization is the cornerstone of international relations and diplomacy. So this principle is grounded in the belief of sovereign states and their official representative in their conduct and affairs in the domestic state or in the state of local forum from interference by the domestic laws of the state. This principle, long recognized in customary international law and codified in various treaties and conventions, aims to protect the dignity, independence, and functionality of foreign representatives operating within a host state. We've talked about this already. So, in contemporary international law, these immunities are primarily codified in Vienna Convention on Diplomatic Relations of 1961 and the Vienna Convention on Consular Relations of 1963, both of which have been widely ratified and are regarded as reflecting customary international law. In Nigeria, the doctrine of immunity for diplomats and international organizations has been adopted and domesticated through local legislation, most notably the Diplomatic Immunity and Privileges Act. This act incorporates relevant provisions of international law into Nigeria's legal system, thereby granting foreign diplomats and certain international institutions legal protections against civil and criminal proceedings in Nigerian courts. The act also outlines the scope of privileges, including exemption from tax, inviolability of premises, and personal immunity from arrest or detention. However, the application and scope of these immunities remain contentious. There has been several cases where the invocation of diplomatic immunity has led to allegations of abuse, denial of justice to local victims, or tension in bilateral relations. In addition, the rising influence of international organizations and the increasing complexity of their operation within domestic jurisdiction, ranging from development agencies to humanitarian missions, has sparked legal debates regarding the extent of their immunity from local legal processes. Now, another source of legal debate is the distinction between diplomatic immunity, which is generally more comprehensive, and consular immunity, which is limited and functional in nature. While diplomats enjoy near total immunity from civil and criminal jurisdiction, consular agents are generally immune only for official acts performed in the exercise of their consular functions. Understanding this distinction is essential to interpreting how Nigerian court handles cases involving foreign state officials and institutions. Furthermore, the modern international legal system has seen a shift from the absolute theory of immunity, which provides a blanket immunity regardless of the nature of the act, to restrictive theory, which allows suits against foreign entities when they act in a commercial or private capacity. This shift has influenced how some jurisdictions, including Nigeria, evaluate claims of immunity, especially where human rights, commercial transactions, or environmental issues are concerned. So quickly, we look at the concept of immunity. We've spoken about this before, and the root of diplomatic immunity is traced back to the earliest form of diplomatic interaction, particularly ad hoc diplomacy, which marked the first instance of organized interstate representation. As states began to engage in negotiations and conflict resolution, it became apparent that their envoys required protection from interference by host governments. This practical necessity led to the development of customs and legal norms, ensuring the safety and independence of foreign representatives. The principle of inviolability of ad hoc diplomatic envoys can be traced to the religious protections granted by the ancient Greeks to heralds and emissaries on peace missions. These heralds, often regarded as sacred messengers, were accorded immunity from harm, highlighting the spiritual and diplomatic respect attached to their roles. Over time, these customs evolved into a formal legal protection as diplomacy became more institutionalized. Now, in Nigeria, the academic landscape, these debates, in Nigeria, legal and academic landscape, these debates have also been robustly engaged. Notably, Professor Sage, a renowned constitutional and international law expert, argued that diplomatic immunity and privileges are without territorial limitations. He drew a parallel between international diplomatic immunity and the provision of Section 308 of the Constitution of the Federal Republic of Nigeria, which grants immunity to elected state officials, such as governors. Sage controversially maintained that this form of domestic immunity should also be respected abroad, citing the case of Diepre Alaye Messiah, the former governor of Bayelsa State, who was arrested and arraigned in United Kingdom. He contended that federating units in countries like Canada and Australia have been accorded similar immunity abroad, and thus Nigeria should be no exception. This position, however, attracted strong dissent from other legal minds. Most notably is Chief Gani Faweyimi, a prominent human rights lawyer and senior advocate of Nigeria. Faweyimi firmly rejected Sage's interpretation, arguing that under international law, immunity is strictly reserved for the head of state or recognized sovereign representatives, not subnational officials like governors. In a press statement published in Tell magazine on October 10, 2005, Faweyimi emphasized the correct judicial interpretation, maintaining that Alami Isia was not entitled to immunity under international law, and the British authority acted within their legal rights. This divergence of opinions illustrates the complex and often contentious nature of diplomatic immunity, particularly when viewed through the lens of national sovereignty, federalism, and international obligations. The controversy also underscores the urgent need for clear legal definitions and judicial consistency on the scope of immunity, especially in a hybrid legal system like Nigeria that incorporates both national and domestic legal norms. What are the theories of immunity? Basically, we have three theories.
My friend, we
Yes,
don't
sir.
finish the direction you are going.
Well,
Firstly, I want you to know that in this class, we are not discussing immunity generally. We are
Okay, sir.
discussing immunity from suit. Immunity from suit. So, as far as the international organization is concerned, I've already spoken about their own immunity from suit. Okay?
Yes, sir.
Tell me, diplomatic and consular officers, which law regulates their immunity from suit and what does it say?
Okay, the foundation for this, okay, let me quickly talk about the theories which covers how this the position of the law concerning the immunity of immunity of consular and diplomatic officials.
Mm-hmm.
So we have the extraterritorial theory, which historically is the earliest
No. My friend,
Yes, sir.
go to Article 31 of the VCDR and Article 41 of the VCCR. Compare the two. You will be able to tell me what immunity do diplomatic envoys and consular officers enjoy from suit in Nigeria or from suit in receiving states. Then go to our own Diplomatic Privileges and Immunities Act and see what it says with regard to immunity from suit of these two people. Once you have done that, you have taught us enough about immunity from suit of diplomatic officers and consular officers. We are not looking at all the immunities. We are not even qualified to look at it. Our own is suit, jurisdictional immunity.
Okay, my colleague will be taking that part of the work because I was just to take the introductory part.
You have introduced the topic enough. Let your colleague address us on that one.
All right.
Okay, good evening, everyone.
Good evening.
Good evening.
I'll be speaking on the legal framework for immunity in Nigeria, discussing the international principles of immunity, how it is received, interpreted, and applied in Nigeria. In Nigeria, we have this discussion structured in 5 parts. We talk about domestic legislations, constitutional provision, international legal instruments, and then immunity of international organizations. So in Nigeria, we don't have a single codified statute that comprehensively governs immunity. However, immunity derives its legal backing in Nigeria from domestic legislations such as the Diplomatic Immunities and Privileges Act, which domesticates the Vienna Convention and diplomatic relations. We also have judicial decisions, a few of them. And we also have incorporated international treaties, also being part of what constitutes framework for immunity in Nigeria. For under the Diplomatic Immunities and Privileges Act, diplomatic agents and their families, administrative and technical staff of diplomatic missions have their scope of immunity provided for. Diplomatic agents enjoy complete immunity from both criminal and civil jurisdiction. Criminal and civil suits, except in limited cases, such as private immovable property not held on behalf of the sending state, succession where the diplomat acts as an executor or heir, professional or commercial activities outside official function. The technical and administrative staff of diplomats also enjoy similar privileges, but theirs is quite limited in scope. Family members of the diplomats, principal diplomats, are also granted immunity, which is commensurate to what the principal diplomat enjoys. For consular officers, immunity is functional, which means that it covers only acts performed in the course of their official consular duties. And this is in line with the Consular Conventions Act, which implements Vienna Convention on Consular Relations. Based on this, we therefore observe.
You said Consular Conventions Act. Is there any legislation like that in Nigeria? Or are you talking about Vienna Convention on Consular
Vienna
Relations?
Conventions, Consular Relations, yes, bro.
Okay.
Vienna Conventions on Consular Relations. So we observe an hierarchy here, which is that the diplomat immunity is broad and is personal, whereas the immunity of the consular officer is limited and based on his functions. This also brings us to constitutional underpinnings of.
What is the distinction between criminal and civil? Tell us specifically how the immunity operates in respect of criminal proceeding and in respect of civil and administrative actions. I hope you understand me.
Yes, I understand you.
Yes. And how do we contrast consular officers with diplomatic envoys? I'm waiting. You don't have time, Mo.
Apologies, sir, we don't have that covered.
Okay. Article 31 of VCDR, Vienna Convention on Diplomatic Relations, says.
Okay, the Vienna Convention on Diplomatic Relations qualifies the immunity of diplomatic agents in civil and administrative jurisdiction in respect of 1. A real action relating to private immovable property situated in the territory of the receiving state, unless he holds it on behalf of the sending state for the purpose of the mission.
Good.
Then number 2, an action relating to succession in which a diplomatic agent is involved as executor, administrator, heir, or legatee as a private person and not on behalf of the sending state. Then thirdly, an action relating to any professional or commercial activity exercised by the diplomatic agent in the receiving state outside his official function.
So that is civil and administrative jurisdiction. What of criminal jurisdiction?
Okay, for the criminal jurisdiction.
Is the same paragraph 1 you are reading, the starting point. Read the starting point of paragraph 1 of Article 31. Should I read it?
Yes,
Article 31. It says the diplomatic agent shall enjoy immunity from the criminal jurisdiction of the receiving state. Do you understand?
Yes,
so,
sir.
It does appear as if his immunity from criminal jurisdiction is absolute, but his immunity from civil and administrative jurisdiction he enjoys subject to those three exceptions. He will enjoy them, but in his personal capacity, under those three exceptions, he can be sued. So can you contrast that with that of the consular officer? Did you look at the Vienna Convention on Consular Relations?
Yes, sir.
So what does it say with regard to, let's start with criminal jurisdiction. Does it confer any immunity from criminal jurisdiction of receiving state court on consular officers?
No, sir. Foreign
So
consular
then,
officers enjoy no immunity from the court of the receiving state in respect of their private acts.
okay.
That's Article 43 of the Act of the Vienna Convention on Consular Relations.
Okay. So that's what we want to see. But have you looked at our own domesticating legislation? What does it say? That is Diplomatic Privileges and Immunities Act. Diplomatic Immunities and Privileges Act, Cap D10, LFS, 2004. What does it say?
I don't think the Nigerian.
Yes. Go on,
The
go on.
Nigerian, as I'm trying to check, it's not. I don't think we addressed it.
Our own statute use a formula enacted in 1962. It says that they will enjoy the immunity that they have immediately before the enactment of that statute. Okay? And
Yes,
he then lists the previous presenter was telling me the category of people he listed: diplomatic officers, consular officers, chief representative of a Commonwealth country, international organization, all of them. But he doesn't tell us the standard. He only tells us that they will enjoy what they enjoyed immediately before that 1962 legislation. And so we assume that it is telling us that their immunity will be as was prevailing as at that time. And in that way, we can say the 1962 Act simply preempt or domesticated the two VCCR or VCTR and what have you. But what is the actual practice? What is the actual practice? We are not going to go into diplomatic and consular law in detail, but that is enough for us to know that, yes, as far as diplomat is concerned, in their person, if you take them to court in their person, they will enjoy also these categories of immunity. Okay?
yes, sir.
International organization we have already discussed.
Yes, sir.
International organizations are not states. They are not state agencies. They are not state institutions. Contrary to what Nigerian courts have been doing, their own regime of immunity from suit is dependent on their own internal mechanism. If they have internal mechanism, then states, whether such states are members or non-members, would accord them that respect and allow their internal mechanism to govern the resolution of disputes. But if they do not have what we have learned from the European courts that have relied on their own Article 6 of their Human Rights Treaty, is that the need to afford people a hearing is superior to the need to respect any particular organization. Therefore, the European court have said that they have given the directive, they have shown us the way that we should actually listen to people's cases against them. And so if we are going to apply that principle, you are going to see that Fantaye was fantastically wrong. The other two cases, the final decision, lovable, but still, because it is based on a principle that was meant to apply to state immunity, we have nothing else to say than that they were also wrong. Okay?
Yes, sir.
Is there any other thing we say you should talk about there?
No, sir. That's it, sir.
Let's take paper 15. Seminar paper 15 now. Is seminar paper 15 is talking about United Nations Convention, Abi? Hello?
Yes, sir, it is. Yes, sir. UN Convention on Jurisdiction, Immunities of States and their Property.
Yes.
Yes, sir.
You know what I want you to tell us?
Yes, sir.
We are getting it now. What is the status of that convention presently? Of course,
Okay.
Nigeria
Members
has
of
not
group,
signed it. Yes. What is the status of the convention? Has it entered into force?
members of Group 15, please go on.
B, you have to answer.
Good evening, sir.
Yeah,
Good
good
evening, Prof.
evening. Yeah.
Good evening. Good evening, colleagues.
Good evening.
My name
Good
is
evening, sir.
Judith Anyao. I'll be presenting for Group 15. Hello, Prof. Can you hear me, sir?
I'm hearing you. I'm hearing you.
Okay. I'll be presenting for Group 15. I'll call my group members out now. We have Judith Anyao. We have Monisola C. Ayinde. And we have Afolabi Olalekan Kalajaye.
Good evening, sir. Good evening, Prof. Good evening, Prof.
Good evening.
Okay, so Mr. Afolabi Olalekan is present in class. So, Prof, our topic is analysis of the UN Convention on Jurisdiction, Immunities of States and their Property. So, in this we have the topic is divided into four aspects, and then the last one, which is the recommendations and the conclusions. So this one we're talking about, the introduction talks about that the doctrine of state immunity has not stood as a fundamental principle of international law rooted in sovereign equality of states and their independence from external adjudicative authority, whereby one state cannot be sued in the cause of another state under any circumstances, regardless of the nature of its acts or transactions. Under this type of, that's where they've discussed previously the restrictive and the absolute immunity. That's the under restrictive one. That's where we have the jus imperata, sovereign acts, and jus decisionis, that's a private or commercial acts, which this convention, that's the UN Convention on Jurisdiction, Immunities of States and their Properties, which is the convention is more or less advocating that acts done in their personal capacities should not be immune from adjudication in court. So the UN Convention, to address these inconsistencies, the United Nations Convention on Jurisdictional Immunities of States and their Property. For this class, I'll abbreviate it to UNCSI. Was adopted by the UN General Assembly on the 2nd of December 2004. The convention establishes that states shall be immune from the jurisdiction of the courts of another state, subject to enumerated exceptions, notably those which are exceptions concerning commercial transactions, which is Article 10 of the UNSCI, employment transactions, which is Article 11 of the UNCSI. Article 13 talks about personal injury or damage to property. Sorry, Article 12 talks about personal injury or damage to property. Article 13 talks about ownership, possession, and use of the property, which are the exceptions under this convention, which tilts towards restrictive immunity to an extent. Despite its significance, the convention has not yet entered into force. As of 2023, the UNCSI, that's the convention in short, has only 23 states rectified. That's only 23 states has rectified it, which is falling short of the required number of 30 states. Then we now moved about to the evolution of the doctrine of state immunity. That's the doctrine of state immunity has long served as a fundamental tenet of international law, rooted in the maxim par imparem non habet imperum. That's one sovereign does not have authority over another state. The concept was judicially articulated in the late 19th century cases, such as the Schuyler Exchange versus McFadden, where Chief Justice Marshall of the United States Supreme Court famously ruled that a national court could not exercise jurisdiction over a foreign warship present in its territory with the host state's consent. Then, down to the 19th and the 20th centuries, that was where we had the absolutist approach. That's the absolute immunity approach. Also, as early as the mid-20th century, national courts began to adopt what became known as restrictive immunity. That's in the 20th century, it was now tilting from the absolute immunity, which was in the 19th, down to restrictive. That's which the doctrine now went down to the acta juri imperi, that's sovereign acts of public acts, and acta juri jurisdiction is private or commercial acts. Then, as a seminal moment in this shift occurred with the issuance of the Tate letter, that's by the United States Department of State in the 1952, which formally adopted the restrictive theory for application in the American courts. The UK on its own also we have something similar, which is the Immunity Act of 1978, which is enshrined in that's the UK own, which enshrined the restrictive theory in statutory form and introduced several important exceptions to immunity, including those related to commercial transactions, personal injury, which is just something similar to what we have in the convention. These legislative measures reflected an emerging international consensus that sovereign immunity must be balanced against the demands of justice. Then, Article 10 and 17 of the convention carefully delineate circumstances in which states cannot claim immunity, which aims to strike a balance between requests for sovereign equality and the rights of private parties to seek judicial redress. Then we now went to we now went to the scope and objectives of the Convention on Jurisdictional Immunities of States and Their Property. That's the convention, that's United Convention on Jurisdictional Immunities of States and Their Property, was adopted by the Union General Assembly on the 2nd of December 2004, which represents a significant development in the codification of international legal principles governing immunity of states from the jurisdiction of foreign courts. Its primary objective is to codify and clarify the rules of customary international law concerning jurisdictional immunities of states and their property in civil matters, thereby providing consistency, legal certainty, and predictability across jurisdictions. The restrictive theory is a departure from absolute immunity, which shielded sovereign from all forms of judicial processes, even if those activities were done in their personal capacity, e.g. commercial transactions. The heart of the convention lies in the affirmation of the restrictive theory of immunity, under which immunity is recognized for sovereign or public acts, but not for private or commercial acts. However, this does not apply to criminal proceedings, nor to certain sensitive matters, such as diplomatic immunity, the immunity of heads of state of acts of armed forces. Moreover, It does not regulate the immunity of international organizations or issues of state responsibility under international law. In so many jurisdictions have actually tilted towards the convention, although some are still yet to ratify it, even Nigeria. Then we now have Article 10 permits jurisdiction over states in disputes. Some key provisions of the convention, there are next circumstances in which states may be subject to the jurisdiction of foreign courts. For instance, Article 10 permits jurisdiction over states in disputes arising out of commercial transactions. Article 11 addresses employment contracts between states and individuals who are nationals or habitual residents of the forum states. Article 12 covers cases involving personal injury or damage to property occurring in the territory of the forum states. We now have Article 13 addresses disputes over ownership or use of property. Article 19 provides that property used for sovereign purposes is immune from execution unless the state has expressly consented to enforcement or has allocated the property for a purpose connected with the dispute. Then, importantly, the convention preserves the principle of state consent as a cornerstone of jurisdiction. Article 7 reiterates that a state's immunity may be waived explicitly or implicitly, such as by initiating or intervening in proceedings. The convention promotes the rule of law in international affairs by ensuring that states cannot unduly rely on immunity to avoid responsibility in civil matters where they act as ordinary commercial actors. The main gist here is just that if the state does not consent to it, there's no jurisdiction in it. We now have the key provisions of the convention. A fundamental provision of the convention is Article 5, which is the general principles. It affirms that a state enjoys immunity in respect of itself and its property from the jurisdiction of the courts of another state, but also makes it clear that this is not absolute. Article 6 builds upon this by stipulating that immunity applies only to acts performed in the exercise of sovereign authority. Which is more or less like a replicate. The language aligns here with the approach of many national courts and legislations, such as the UK States Immunity Act of 1978. Then we also have the US Sovereign Immunities Act of 1976, which is also similar to the convention. Article 10 addresses commercial transactions. It provides that a state shall not be immune from the jurisdiction of a court of another state in proceedings relating to commercial transaction with a foreign person or entity. Importantly, the article defines commercial transactions broadly to include any commercial, trade, or business activity, thereby capturing a wider array of state conduct beyond the traditional remit of sovereign transactions. Article 11 deals with employment contracts, whereby a state employs an individual who is a national or habitual resident of the forum state, provided certain conditions are met. Article 12 is talking about personal injuries. That the state is not immune in proceedings relating to personal injury or damage to property caused by the states in the territory of the forum. Then Article 13 concerns itself relation to dispute, relation to ownership and also of ownership and the use of immovable property. This rule ensures that states do not use the immunity doctrine as a shield when acting as private property holders in a foreign jurisdiction. Article 14 permits a state to be joined as a party to proceedings. Article 15 recognizes that states may waive their immunity either expressly or by implication, such as by voluntarily appearing before a foreign court without invoking immunity. Article 16 ensures states are notified properly of proceedings instituted against them. Article 17 outlines default judgment procedures in the event that a state does not appear. Article 18 affirms the general rule that a state's property is immune from enforcement measures, while Article 19 outlines exceptions to this. In particular, Enforcement may be allowed if the property is used for non-sovereign purposes and has been allocated or designated for such, or if a state has expressly consented to enforcement. That is when you can use, that's when the property of a state can be used in relation to enforcement of a judgment. Article 21 enumerates categories of property considered immune from enforcement, including property used in diplomatic missions, central bank reserves, and military equipment. Then we now have the legal implications of the convention. The convention mitigates the predictability and divergent judicial practices that had long plagued cases involving foreign sovereigns. Yes. One significant legal implication of the convention is the reinforcement of the restrictive theory of immunity as a prevailing legal standard. The convention unequivocally limits immunity to acts performed in a sovereign capacity, excluding commercial and other private activities from immunity protection. The convention's provisions regarding waiver of immunity also carry important legal effects. Now we're under the waiver, we have Article 7, clarifies that immunity may be waived explicitly or implicitly. This encourages transparency and including by a state's voluntary appearance in court or through contractual clauses consenting jurisdiction. I've said that before. This encourages transparency and predictability in international transactions, where parties may agree in advance on dispute resolution mechanisms without fearing immunity-related obstacles. It also aligns with principles of party autonomy prevalent in private international law, thereby bridging gaps between public international and commercial transactions. It addresses, that Article 18 to 19 addresses a major practical challenge in international dispute resolution, the effective execution of judgments against states, functions, and allowing enforcement against commercial assets help ensure that successful litigants have meaningful remedies. Many states have either aligned their domestic laws with its principles or cited it in judicial decisions, thus promoting greater uniformity and predictability in the application of state immunities. The convention, however, does not resolve all contentious issues in state immunity. For example, it preserves the immunity of certain categories of property, such as those used for diplomatic or military purposes, reflecting enduring sensitivities around sovereign dignity and security. Additionally, it leaves open questions regarding immunity in cases involving serious international crimes or human rights violations, which remain subject to evolving customary law and regional legal developments. In summary, the legal implications of the convention are multifaceted. It represents a significant step towards harmonizing international legal standards, enhancing the rule of law in cross-border civil disputes involving states, and balancing respect for sovereign with access to justice. Then we have how the convention influenced customary norms. Yes. Before the convention's adoption in 2004, the rules on state immunity were largely derived from customary practice, judicial decisions, and a patchwork of national legislation. International courts and tribunals have increasingly referred to the convention as evidence of customary international law. For example, the International Court of Justice, the ICJ, in jurisdictional immunities of the states, that's Germany versus Italy, explicitly acknowledged the convention as a key source reflecting customary norm on state immunity, underscoring its authoritative role in the international legal order. However, the convention's articulation of the restrictive theory of immunity, distinguishing between sovereign acts, that's jus imperii, and commercial acts, jus decisionis, has solidified this doctrine as a prevailing customary standard. It has also reinforced the norms that states enjoy immunity only in respect of sovereign functions, while commercial and private acts fall outside immunity protection. This marks a clear departure from the earlier doctrine of absolute immunity and illustrates the Convention's impact in crystallizing contemporary customary law. The Convention has also contributed to shaping customary norms around the immunity of states' property from execution, balancing the need to protect sovereign assets with ensuring effective remedies for claimants. By defining specific categories of immune property and underlying conditions under which enforcement measures may proceed, the Convention has provided clarity that has been gradually absorbed into state practice. Arising from commercial enforcement, state practice, this clarity helps reduce diplomatic friction arising from enforcement actions and facilitates greater predictability for litigants and states alike. Further, the Convention provisions on waiver of immunity, allowing states to expressly or implicitly consent to jurisdiction, have been widely embraced as a customary principle, encouraging states to engage more openly with foreign judicial processes. Despite its influence, the Convention does not exhaustively resolve all issues related to state immunity, particularly emerging areas such as immunity vis-a-vis serious international crimes or human rights violations. The UNSCR, that's the Convention, has significantly influenced the formation, consolidation, and evolution of customary international law on state immunity by offering a comprehensive, widely accepted legal context that reflects and shapes state practice and opinion juries. It stands as a benchmark for states and courts worldwide, fostering legal certainty and uniformity in the treatment of jurisdictional immunities and sovereign properties. We now have the strengths and the weakness of the Convention. Among its key strengths is its comprehensive and detailed approach. The Convention systematically addresses diverse aspects of state immunity, including jurisdictional immunities, immunity from enforcement, and treatment of state property. That's another major strength of the Convention: reaffirmation and elaboration of the restrictive theory of immunity by clearly distinguishing between sovereign acts and commercial or private acts. I'm talking now about the strength of the Convention, that's the advantages. It distinguishes between foreign acts and sovereign or private acts. The Convention aligns international law with contemporary realities, where states increasingly engage in commercial enterprises. Thirdly, this distinction enhances fairness. It enhances fairness by preventing states from hiding behind immunity in commercial disputes while preserving sovereign protections for truly governmental acts. Then, that's for truly governmental acts. Thirdly, the Convention's provisions on waiver of immunity also represents a practical strength. That is, it recognizes both explicit and implicit waivers, which encourages parties to negotiate jurisdiction clauses confidently, knowing that immunity will not automatically bar access to justice. Fourthly, by delineating categories of immune properties and allowing enforcement against assets used for commercial purposes, the Convention facilitates effective remedies without undermining sovereign functions. Now, the weaknesses. That's a disadvantage. One notable limitation in the lack of universal acceptance and entry into force. Like I said, some states are yet to rectify it. Since its adoption in 2004, insufficient ratifications have delayed its implementation, limiting its capacity to unify international practice and to resolve conflicting state practices definitely. Another weakness concerns the ambiguity and gaps that are evident in some areas, such as when talking about international crimes or human rights violations. That's the Convention is lacking in that regard. The Convention does not explicitly address whether immunity may be denied in proceedings alleging violations of jus cogens norms. Leaving this
They have said
contention
that
to
one
the...
before now.
Okay, I
Have you
explained
not
that.
said that one before, that it has a limitation, that it doesn't
Yes,
address the
yeah,
emerging concerns with regard to human rights violations and all of that?
yes, sir,
But
that's
you
it.
also
Thank you.
said there that it is better to leave customary international law to involve in those areas.
Yes, sir.
Eh?
Customer international is ever evolving.
Well, an
That's
international
another one,
treaty.
sir.
No, let me make a comment. An
Okay, sir.
international treaty is one of two things: either a codification or a progressive development. Codification is when customary international law has become settled on a point, and it is taught by member states of an the world or of a region that the time had come for it's being put in black and white. That's codification. Okay? Progressive
Yes, sir.
development is when, having reviewed the situation of customary international law and the emerging issues, you preempt those emerging issues by providing answers to them in a treaty. So the relationship between a treaty and custom is also very important, as publicists have taught us, because customary international law is a mirror of usage. Yes, it is a Nigerian case where somebody, that somebody said custom is a mirror of accepted usage. Because it's a mirror of usage, some of the time when you find the world overwhelmingly ratifying a convention, that in itself will make the provision of that convention to become customary international law. Okay? So,
Okay, sir.
if you look at the United Nations Convention on Jurisdictional Immunity of States and their property, there is virtually nothing new. There is no provision of that treaty that you will not find being identical to a similar provision of the FSIA, Foreign Sovereign Immunity Act of America, or the State Immunity Act of England, or any of the other pieces of state legislation that have been enacted on immunity. There is nothing in the convention that you will also find contradictory to the existing regional treaties on jurisdictional immunity. So, in a sense, it is largely declaratory or a codification of what the state of customary international law has been. And the recommendation we usually make is that for states like Nigeria that do not have a state immunity legislation, they can begin by adopting this one, which is more or less a codification of the word practice on the matter. And you can imagine all of the 10 or 11 circumstances when this convention says states will no longer be able to plead immunity in foreign land when they are sued. If that had been applied, cases like Rema Italo or Oluwalogbon Motosu or would have been decided differently. They clearly would have been decided differently because they will come under one of the exceptions covered by restrictive immunity or the other. Instead of our courts struggling to when they even want to say that they accept restrictive immunity, you see them struggling with their reasons. And most of the time when they say they are rejecting, they say they are allowing immunity to be pleaded, they will be claiming one thing, but when you compare it with what the practice of the world is, it will be far away from being correct. And Nigeria has no good reason to allow our own citizens and businessmen to suffer simply because it will remain stuck with an old-fashioned concept of absolute immunity that was not intended to save foreign states from liability, but it ends up doing so. Because if the only place where you will be able to sue somebody whose driver has damaged your car in Nigeria is that person's country, then you look at the cost. You look at the cost and all of that, and you would probably give up.
Yes.
So indirectly, immunity is turning to indemnity. And it is often said that jurisdictional immunity is a mere procedural bar. It was not supposed to confer indemnity. But if the cost of going to sue the foreign state or the foreign embassy in the sending state is going to be so high, indirectly you would have prevented the suit from being maintained. So just take note of all of the instances when it is now permitted to sue a foreign state that has acted in another forum, in that forum. That is, you sue it for acting in that forum. You sue it in the place where it has acted. So suppose it has acted in Nigeria and action is going on in Nigeria against it under those exceptions. The action will go on and its immunity plea will fail. But if it has acted in Nigeria and action is being instituted against it in, say, Benin Republic, it will be able to plead the immunity. You should take note of that. If it is sued in the place where it has acted, it won't be able to plead those immunity. So we have all the exceptions listed there. Commercial transactions, broadly defined, not confined to what His Lordship Apata JCE was ready to admit as commercial transaction. You have employment. If you employ somebody abroad and the person has issues with the employment abroad and it takes you to court there as a foreign state, unless the person is employed in those circumstances where you are permitted, maybe he's an ambassador, he's a diplomat or whatever, the receiving state should respect you and not allow that to be litigated in their court. But if he's just employed to do clerical assignments and all of that, and he has issues with you, you won't expect him to come to your country to come and sue you. The state where you have engaged him to work, you should be able to entertain the case. Immovable property. The logic behind the movable property has been well explained. Most countries will not permit a suit against a person in respect of property located abroad. It then means that by the rule in BSc and Comprehensive Mozambique, you will only be able to sue where the property is located. So if a foreign sovereign comes to Nigeria and acquires land, and issues arise from that, whether there is a third party that say, no, it's my land, it was not properly acquired, or whatever. For you to say that because it's a foreign sovereign, that person cannot sue, is to say that that person will never be able to sue anywhere. And the starting point of jurisdictional immunity is that it is a mere procedural bar. It doesn't protect the immune entity from liability. So if you now say you don't want to sue it in respect of land it has acquired in Nigeria, here in Nigeria, you will go abroad. When you go there, the court abroad will tell you, how can you come and sue here in respect of foreign land? So it has always been said that that is one exception that even centuries ago has been recognized to the immunity plea. And so when you find a convention or a state immunity legislation or a regional treaty recognizing it, you can then see that all that has been done is to codify what has always been known to be the position. 4, sometimes states enter into partnership and they do not enter into that partnership with fellow states. If they enter into the partnership with fellow states, you will have an international organization. But they enter into it with individuals and other juristic persons abroad. So that relationship, whether it be as a company or as a partnership, will be regulated by the law of the place where they enter into it. And when there are breaches, when there are complaints, it is the courts of the country where they enter into that relationship that the complaints will be taken to. How can you then imagine that a foreign state that has brought itself down to that level should be able to plead immunity and then say that every complaint must now go on in its own territory? The United Nations Convention says that is not going to be possible. If it has entered into a partnership or become a shareholder in a company in a foreign land, it cannot plead immunity when issues relating to internal affairs of that partnership or company is being litigated in the place, in the country whose law governs the relationship. The same thing with patents, patent and intellectual property. If you acquire patents or other intellectual property that is governed by the law of another state, you cannot prevent litigation in that state when issues relating to violation of patent rights is concerned, have been instituted in that state. Then we have the question of tort. You've seen what happened in Ll.M, and we have told you that Ll.M will never happen in England because of the relevant section of the State Immunity Act. That section of the State Immunity Act is repeated in every statute on jurisdictional immunity. It is repeated in every convention on jurisdictional immunity. And so when the United Nations Convention states it, it is merely doing what it should do, which is a codification. And that's why we are saying, if this convention had been in place when Ll.M was decided and Nigeria had ratified it, Ll.M would have been decided differently. And the judge would not have struggled to find the reason for saying that UK, whose own internal law would not have permitted immunity to be raised if the facts were to be reversed such that it is the Nigerian embassy that is being sued in England. But you see, our judges, they struggle to find the reason, okay? Instead of them to rely on customary international law. If Nigeria ratifies this convention, they won't need to look for reason again. We ratify and domesticate it. That would be their reason for saying that in that circumstance, UK should answer. Then we have the question of exclusive foreign jurisdiction clauses. States can enter into agreement with people and agree that the court of other states will be the ones to entertain their dispute. In the past, when they did this, because the immunity regime was absolute, they still would have to waive that immunity when action has been treated. That's what the case of Kahan and Pakistani Federation. Kahan and Pakistani Federation established. Yes, Pakistani Federation. Kahan and Pakistani Federation, which says that you cannot waive immunity before action is filed. So any agreement that the sovereign had made with you that he won't go to court amounts to nothing until after the case has been filed and it actually does not object to its continuation. So waiver has a specific meaning under absolute regime. It is post-action waiver. After you have filed the action, the sovereign comes and says, yes, I will enter appearance. I will defend. Which means that the sovereign is given the opportunity to renege on his promise. But under the restrictive immunity regime, if he agrees with you that you will sue in a foreign country, he does not even have a second power of waiver again. If he comes to say, I want to plead immunity, you answer him with that exclusive foreign jurisdiction agreement, and the court will uphold your argument. The same thing with arbitration. States may be party to agreement where they succumb or surrender to arbitration by a foreign arbitral panel sitting in foreign land. Under the absolute regime of immunity, that still would not prevent them from being required to waive. And if they refuse to waive at the appropriate time, so be it. But today, the restrictive regime of immunity would deem that they have waived that immunity from the moment they agreed to arbitration under a foreign lex arbitri. Okay? So, the usefulness of the convention, as I have told you, is that it has codified current customary international law on the matter of on the proper regime of immunity, and all of the 9 or 10 circumstances when a foreign state will not be permitted to raise immunity are identical to what you find in the plethora of state legislations on immunity, international or regional treaties on immunity. And it is good for countries that have never thought of enacting a state immunity legislation to just start with this as a model. The other issue is the issue of execution. Incidentally, all of these provisions do not govern enforcement. The position remains as it used to be at customary international law, that states can plead immunity from enforcement of foreign judgment. Okay? And as a general rule, they can plead immunity. There was a time when we were discussing the seizure of Nigerian, no, not that one. We were discussing this issue of the one that Nigeria eventually was able to wriggle through during the Malami Attorney General thing. Can you remember the case? Can you remember the issue when some people...
PNID brought.
The PID case, okay? The position remains the same, and it does appear as if the United Nations Convention was not able to change the law. But like I told you, the UN Convention was not meant to change the law. It was just meant to codify what the world had agreed upon, okay? So, on that note, I think we have concluded everything we need to say about jurisdictional immunity. We have only one major topic left: enforcement of foreign judgment. I'm sure that if you say you have 20, I'm sure that we have 5 papers. We definitely cannot take 5 papers next week. Okay? I will look at, I hope we have all the remaining papers, 16, 17, 18, 19, 20. I will look at them and select what 3 we are going to take.
Okay, sir.
I will look at them and select what. Let the class governor report to me the seminar papers 16 to 20. I will look at them. There must be some 2 or 3 that will represent everything we want to know on enforcement of foreign judgment. And those are the ones we are going to take next week. And then by upper week, we should be telling ourselves areas of concentration. It's been a long semester. We need to rest.
Thank you, sir. Yes.
So I see you
Thank
next
you,
week.
sir.
Thank you, sir.
Thank you, Prof. We appreciate, sir.
Thank you, sir.
More strength, sir.
Thank you,
Okay.
sir.
Thank you, Prof.
Nice,
Thank
sir.
you,
Thank you,
sir.
sir.
Grateful, sir. Thank you, sir. Thank you, sir.
Bullet. Bullet. Mo fẹ́ jáde tẹ́lẹ̀ bọ̀ nígbà mo máa rí ìdílé tó yẹ pé kí n ṣe ọ̀nà. Mo fẹ́ jáde ní 11, mo ti múra already. Máa pọ̀ lẹ́ẹ̀kan sí. Mo ti mú dàgbà yẹn náà. Mẹ́sẹ̀jì wo nìyẹn náà? Mo ti rí, mo rí. Sọ́kà mi wo tún yẹn? Èwo ni exemption? Ó kè ṣe yẹn, ìwọ náà bá mi tàn yẹn náà. So both the one solve the problem you have. Tomorrow. Come. Master project. You just want one signature on this. On this beach. Okay? Signatures in the forge. That's okay. I won't. Also. And the other people who already sent something to me.
You're done.
Maybe you should witness or a letter also.
Okay, I should witness.
And after the forged the letter also signature of the check.
Okay.
You should witness for her. Maybe you witness for her before you take it there.
Let me do it outside. Let me do it outside.
Then you can feel the land from once. There are two other things to be done. Photograph of the property.
Yeah, that's the distance.
And sketch.
Location.
Somebody will have to visit the land I will get a surveyor to help me do location sketch. Huh?
Okay.
And take photograph of the house. Hey, is that assigning? Yes.
Yes. Occupation students.
Yeah.
Legal practitioner.
Legal practitioner. Kí ló lọ́gbọ̀n ní gbogbo legal practitioner? Ẹyọ̀kan ni mo ṣe. Ẹyọ̀kan ni ń ká sí nísìn.
No, take it to English.
You.
Pharmacy.
But you can feel it first.
Yeah. But you stamp it.
But kó tẹ̀ kọ́kọ́ for the signature àwọn sign náà sílẹ̀. Send something. Ṣé kí ni wà ń bẹ̀? Evidence of submission wà ń bẹ̀.
Government.
Ó gbọ́dọ̀ wà ń bẹ̀.
Is this what you have?
Is that not evidence?
See, OSFG number February.
What do you say?
State Surveyor General. The one they give them.
But not now.
The one they submit, the surveyor submit. OSSG itself gives them another one with the Lagos stamp permit that shows that it has been successfully submitted.
So are you saying that this one may not be done?
Mm.
Yeah. So what are we going to do?
We can see this one pending. If it's queried, then here we'll not bring that down.
Because I want to see where it means. of being called.
I've not even gone to see Mr. Okay. I didn't give him another work again.
Let me talk. They don't waste my time now. The client is on my neck.
Wọ́n ṣe gbọ́n nǹkan tẹ́ ẹ sọ gan ni. Ó fà á pé ìwé lè gbọ́n. That time, that was my big that because of what got pregnant first, probably now it's not on but they didn't go to because you know that way. Yeah. So that time now, maybe 7 months, 8 days. 7 days probably, 1 week today. Yes. Was not looking at if they ask me. But she knows that they can stop down. Wow. Yes. We don't have the for madam. What am I, mom? Maybe, but I say with Banja, the way you understand here, you go back and say, if we I want to follow see big that one should not go back to right. That's if I want to play the man with mamu. Only one see anyone in the continue with you. That's what the man was saying. So that's it. Ẹ ṣàmọ̀ pé lọ́dọ̀ tiwa lọ́fà bàbá máa ṣe wé ní ìsìnkú nọ́mbà rẹ̀ ẹ má ṣe bẹ́ẹ̀ ni bẹ́ẹ̀ ni. Tí wọ́n bẹ́ẹ̀ ní mọ̀ nǹkan tẹ́ máa ń sọ tó tọ̀ bẹ́ẹ̀ ni náà ni. Àwọn ní Nicola ti 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 tọ́ ọ ní àwọn ará dókítà yẹn ó wà rẹ́ àlùbọ́sà di wọ́n wá ní ṣé àlùbọ́sà yẹn wà níbi ó já ó já àwọn tá ní tọ́jú àwọn gẹ́ẹ̀tì ẹ̀ ní àwọn sì sọ pé àwọn ṣì máa ṣá yẹ̀ pé. Baby, they don't even go out to even learn. No. But are you sure? It's from there now, you remember? She's from there. She's not going anywhere. I'm sure I know. You know, no, you know. But all those places, but I'm only was telling me, I'm there, you know. Yes, so stay with me. I see Yes, so it's clean blood. I know. It's just a moment. Wọ́n sọ fún wa ẹ ṣe o láàrin ìlú lábẹ́ àwọn àbáyé orí ọmọ ọ̀gá o. Òun náà wá sọ pé ó ti bàbá. No, the interest wasn't from a phone. Yes. There was already someone in the picture. She already got someone in the picture already. That's the only thing. But they follow only son drive. Oh, the only son. Only shy bunny. Yeah. Àwọn international students náà miss class. Ebi kan tẹ́ ẹ bá lọ sọ́hun yẹn nìyẹn. Ọpọlọ. Ibẹ̀ sí ló máa rí bókù ní sàwọn. Ara máa balẹ̀. They are really revoking left, right, and center. Ọ̀fà ni yàlájà. Ẹ̀wọ̀n. Ọ̀fà ni wọ́n. Orí ọ̀fà ni ìtúlé wọn náà wà. Ẹ náà lọ pẹ̀. Irọ́ nǹkan tó máa ń bọ̀ nǹkan mú bẹ̀rẹ̀. Wọ́n á pè mú bọ̀ wá fẹ́lẹ́ ra nǹkan. Kí ẹlẹ́jà máa ń pìkì àwọn ọ̀nà tí kémi lọ ra àwọn àtàrí ìfẹ́. Nígbà tí wọ́n wo ìgbà tí wọ́n gbà tí ìgbà mú ẹ̀ nínú tí wọ́n kúrò mẹ́ àwọn lọ bí oníṣu. Ìgbà padà sí ṣọ́ọ̀bù mú mi àyẹ̀wò wáyé. Kí ni gbọ̀ngàn tí ẹni yìí sọ? Ọ̀rẹ́ wọn rẹ̀ dáná kúrò wọ́n ní pa. Àwọn òbí wọn ni pé báwo ni ìrìn àti máa yẹ ṣe jọjọ́? Ẹni ẹ̀ mọ̀ wọ́n á ní àpé ó bá mi ṣiṣẹ́ nù. Wọ́n á ní à. Èmi wá rí ohun kékeré tí mo lè gbà. Ìbá fẹ́ yàn tó wà ní ìyàwó yìí ó ti fọkọ fúnra rẹ̀ ló mọ́kọ ó mú ìyàwó wá ní fọkọ rẹ̀.
Irú ìyá yẹn.
Mo fẹ́ gbọ́. Ìwà all means ìpè wọn fún mi. Ìpè tí mo fẹ́ gbọ́. Bóyá tẹnu mọ́jọ́ ẹ̀ ní ìjẹ́ ẹ fẹ́ gbọ́. Wọ́n ní ààbò sí ìkọ̀kọ̀ nítorí wọ́n náà yọ nílẹ̀. Etí ẹ dàbí òdi. Wọ́n sọ ọ̀kọ́ fún ẹ̀sìn mo ní mo ti gbọ́ mà. Èmi náà wá délé. No, èmi ò tẹ̀ kúkú wá kéèkì ọ̀rọ̀ yẹn. One day láàárín ọ̀sẹ̀ mi wá lọ bíṣẹ́. So this man saw me. No, I think I went to work. In the of the way oh my. She saw me, she didn't tell me when she wanted anything. Went to you. You understand?
Yeah.
So you can nífẹ̀ẹ́ mi lẹ́sẹ̀ sọ bọ̀ mo sọ pé owó yẹn ká ilé àgbà tó lẹ́ máa ti rí gbogbo owó báyìí àbí àkáǹtì wọn lápọ̀ sí you understand? So dájú náà tó mi pé ìyá alágbádá òun ló ní káwọn fún mi ọba ẹ̀ báyìí pọ̀. Omi àpè ló wá dákẹ́ pé bóyá ó máa yá sọ fún mi. O get? He didn't tell me. Second day, tí mo lè bẹ̀rẹ̀ nígbè náà ẹ gbà pé nǹkan mo suggest pé tí yóò lè torí láti bọ́ àwọn ọmọ yìí.
Lóòótọ́ ló gba kọ̀ǹténà tó ń lò.
Ẹ̀wọ̀n á ní ẹ̀rọ pé ṣọ́ọ̀bù ọ̀dọ̀ ibi ìyá tó yọ̀ yẹn tó fẹ́ gbà tẹ́lẹ̀ ẹ̀rọ tí ó máa ń gbọ́ tí àtúnyọ̀ ló fẹ́ kúrò bẹ́ẹ̀ gbà ẹ̀ ló fẹ́ ta nǹkan bẹ̀ àwa rò pé kó lo bẹ̀ ẹ̀rọ tí ọ̀gbìn tẹ̀ mọ̀kọ́ tó ṣẹlẹ̀ káàkiri níbẹ̀ yẹn tó sọ pé òun máa lò ó pé báyìí pé owó pátọ̀ bí i
lẹ́jà náà ti parí sẹ́fọ́n.
látọ̀dún ìgbẹ́dìgbẹ́. Ààrẹ tàbí títàn sọ pé ó fẹ́ ti dáhùn fún ẹni bẹ́ẹ̀. Now drop that woman. That thing happened 2 times. Not say how. Kujogati. I understand you. Me, you can come and say how we get, but why will you be somebody that is working for me or somebody I know? Get. Now, to my friend, I will go with a wallet to come and see for me. But when I now saw the place, ẹni tó mọ̀ nílẹ̀ tẹ́tẹ̀ ẹni tí ò mọ̀ bìkọ́ kò mọ ibi tó pọ̀ sí kò mọ tó ṣe kí nìkan á máa rí ìsìn á máa ra ṣe jẹ́jẹ́ ìrọ̀lú tó ti mọ̀ ẹ́ kò bá sàbí máa ti pọ̀ jù. Even the one that works for you. Àti kò ṣe gbọ́mì kìíní kan mú mọ́ wọ́n tún lo dáná fẹ́ máa lẹ̀ mọ́.
Àti díjọ ṣe madam. Not madams.
Bóyá fífà ìnáwó wà ní pé tí o lè fẹ́ ẹ̀wò abádájú sọ̀rọ̀ ẹ jẹ́ ká a máa rèézì bọ́tà wá lè rèézì ẹ lọ fi bẹ̀rẹ̀ bísíǹsì ráìsì ní tẹ́lẹ̀ jù. At least dáhùn náà wọ́n máa jẹ èmi náà jẹ kíní kan kò tó ń bè ìkọ́jọ.
Ọ̀dẹ̀ lọ fún ikọ́ lọ́ọ̀tún lọ́mọ nígbà yẹn.
Ẹ má lè fi kiri ẹ̀ dànù omi ẹ̀gbẹ́ yín dànù níbi tó lọ èmi fún ìyá sọ̀rọ̀ bóyá èyí mi náà mú wọlé bóyá kí.
Oyè ìlàjà àti gbòógì lẹ́yìn ọmọ ẹni máa ń gbé yóò gbà.
Ìgbó kọ̀ọ̀kan torí pé.
Ọmọ kéènì wọ́n gbà yẹn náà.
That woman was I knowing older than her or something?
Were you?
Yes.
No.
No.
It's hardship that made her look older.
Don't mind that job. Ẹ ti gbàgbé ni.
Wọ́n gbé dàgbà lọ.
Ṣé àwọn tèmi kéré ni ẹ̀gbọ́n ti pé kẹ́mi lèmi ní kẹ́mi tó dàgbà nígbà yẹn náà ni. Tèmi gbogbo àwọn ọmọ ẹ̀ wà ní skul nígbà yẹn. Ẹ ti gbàgbé. Túndé ni ó ti fẹ́ ṣe tán. Ó tó wá di pé ó wọ polytechnic àbí nǹkan. Ṣé di first form wọn náà? Later the other girl ó sọ fún mi ó lọ lóyún àbí nǹkan and all that. Èmi. Ìyá bá jà. She likes it, and actually God didn't open ways for her there. That she every weekend, right? In fact, you know that she sells half bag of rice in a day. Is that? You know, right? I was sent here, provisions. This picnic, you should better have half carton, half pali. No, pali here, 2 steps now. Yeah. That one that we have is 48 years.
What she's scared.
Buy everything. Everything there. Yeah.
It's not really your problem.
Don't be that time now. If the abaron then, I mean, say abaron then, come on. Don't come in. Abaron then, money. Abaron then, after abaron then, sale, okay, you pay. Now, go down, but that's me, and you pay by.
There's a lot of food traffic there.
Traffic, I'm look at that. I'm look at that. I want to say, only I'm look at that. Everybody, you pay for that. Àbí pé wọ́n ṣí bẹ̀yẹ sílẹ̀ fóun ni.
The main customers. They are men.
Oníkálukú wá dẹ̀ sí ètò fèsì ara wa. Èèyàn ní báyọ̀ dà.
Finish no enter.
Even when you see your husband, they go date one small girl or something. Okay, whatever. Ọmọ yẹn ni wàá mọ bí wàá ṣe rọra gbà. Máa kó sọ́mọ olóyún tó máa fi sá kúrò gbogbo.
No practical to do. But you don't have a husband. You pay but who bomber you?
Magalinu.
Bomber comes on you.
Ẹ̀wọ̀n ni ò fẹ́ ṣe é tó gbogbo yín tọ́lọ̀ ṣàánú. Ẹ̀yin tẹ́ pé etí yín náà kó gbogbo ẹ̀ sí. Àbí ìtòsí yín bí ni gbogbo àwọn bàbá àwọn tó fẹ́ fi dìgbà máa ọpọlẹ̀. Rọ́ọ̀sà. Wọ́n ní pẹ̀lẹ́. Ẹgbẹ́ prọ́fù wọn tó ń ra sẹ́ni báyìí. Àwọn náà tún máa gbórúkọ ẹni yẹn káàkiri. Ẹni yẹn. Lẹ́lẹ̀ gbogbo amáàkì ni. Okay. Is that the same amount now?
Yeah. So, we don't know about what. What is doing with it?
$100K. This is the cheap. That's why I said, don't check in with me. I said, that for our age, I think it's less than 100, like something. I say, people are too small for me. Really? When you talk to me, I will check it. I said, for our age, and I know some people say, I'm just keeping you. I thought you got to like 20. I said, maybe she is people, like, ask and be saying, no, no, to the solution is stop it to this. Like, need to be there, no, I don't know. We say, no, me just tell you, like, if we am so bad, I have one thing to want. I think I'm like 97, 91. Now, how we say you now?
120.
Yeah, no, it's not 200, and it's not good. I check it. Say it's not
I don't
overage.
understand.
Like, I think it's not up to 100. Say.
Which one? Is it the diastolic or systolic?
Wait.
Do you know anything?
Yes, sir. Yeah, and that now.
How can I not those
Up
things?
to
Systolic is not done.
See, I mean, that's what I'm saying. Not up to 100. Take it. I mean, then I told her it's not good. Yes, sir. I said it's not good. She said it's good. I said it's not for her age. It's never. I was saying it's not good. I told her. I really would like you do it. I need to check it. Then I did the house. I check it. Which one is it? And this was me saying it's not good. So that she said, just ask Daniela. People that even lesser than me, they are not more than. Who's good at all? If it's like 100 again, if the view is more than 4, so that we should know.
Maybe
That's what I'm saying. And again, it's just like a bit. And that's really correct. That's what I'm saying. Very plenty back báwa náà ní pé bóun ṣe òun máa ń gbé 70 àbí kí ló pè 70 tó ń fọ́n that's not good now. Ó ní pé ní bàbá òun náà bàbá òun ṣe ń gbé mi. Dáàbò ìgbé yẹn náà wọ́n ní jíjó Ìgbò ni ọkọ̀ ọ̀hún àyè.
Right. Then give or drug.
ìbẹ̀rẹ̀ kó ti tọ́ lánàá.
No, ní ló máa tọ̀nà. I saw it. Oh, I see. I was doing that lecture now. Oh, yeah. Èwo mà nìyẹn o. Ilé èwo nù. Ah, mi ì tí kúrò ní meeting.